Welcome and thank you for joining us today. Our presentation is BVI Corporate Transactions, when things go right, when things go wrong. This presentation will run approximately 45 minutes, give or take, with some time set aside for questions at its completion. Please submit your questions at any time throughout the presentation using the Q&A function, which you will find in the menu bar at the bottom of your Zoom screen. Our presenters today are O'Neill Webster partner Christopher Simpson and partners Christopher Simpson and Dan Wise. Christopher is an attorney in the firm's corporate and commercial and funds and regulatory departments. He advises a client base of leading financial institutions, corporations, law firms, and others on all aspects of corporate finance and BVI funds. Dan practices commercial litigation and asset recovery, where he is engaged to resolve complex, contentious commercial matters, often of a cross-border nature, including those involving an element of fraud. Please visit o'neillwebster.com to learn more about our law firm and today's presenters. We also encourage you to connect with Christopher and Dan on LinkedIn and follow O'Neill Webster on LinkedIn. Okay, with that brief introduction, I turn over the platform to Christopher.
Well, thanks, Jane. Many thanks for that. Good morning, everyone, and welcome to today's presentation. Dan and I are delighted to be able to present to you today on BVI Corporate Transactions, when things go right, when things go wrong. So I'm going to go ahead and share my screen. Okay, so BVI Corporate Transactions, when things go right, when things go wrong. And I think no discussion about BVI companies or BVI corporate law is complete without first an overview as to why people use BVI companies. Why do clients across the globe use BVI companies? And so I'll do an overview of those matters. So BVI obviously is a tried and tested jurisdiction. It has a tried and tested global product in terms of the BVI business company. Over 1 million have been incorporated since 1984, and over 350,000 are currently active and engaged in a wide variety of businesses across the globe. In fact, that figure is about 368,000 as of the end of last year. And the BVI's contribution has been confirmed by the Capital Economics Report of 2017, which confirmed its contribution in terms of the local economy in BVI, and also the wider global community in terms of financial services, jobs, capital flows, etc. So what are some of the advantages why clients come to the BVI? One is low cost compared to some other jurisdictions. Quick setup, BVI company can be set up in as quickly as 24 hours once the appropriate due diligence has been provided. There's flexibility in terms of issuance and transfer of shares, redemption of shares, dividends. There's flexibility in terms of corporate procedures such as mergers, continuations, winding up proceedings, etc. Tax neutrality. BVI does not add an additional layer of tax to the company itself or to the shareholders. So that's an advantage. We have a legal system based on English common law, obviously supported by local statutes. There's a commercial court, the arbitration center, and the BVI has a good regulatory system. It has anti-money laundering legislation, tax exchange information agreements. It has signed on to FATCA, CRS, and they're also registry filings. So those are just some of the advantages why clients come to the BVI and use BVI companies. Now, what are some of the recognized uses? There are many, and here I'll just highlight a few. They're used as joint venture vehicles for cross-border transactions. They're used as private holding companies for asset protection, confidentiality, and transaction flexibility. They're also used in succession planning. They're used for investment funds. And now we have a number of funds. So for example, we have the private, professional, public, approved, and incubator funds. They're also used as IPO vehicles. And BVI companies are listed on some of the largest exchanges in the world, NASDAQ, London Stock Exchange, and the Hong Kong Stock Exchange, to name a few. Now, when things go right, when things go wrong, and what do we mean by that? Essentially, what we're looking at here are some of the key things to look out for in corporate transactions. What is the best practice in certain types of corporate transactions? So these are the things that, the transaction is progressing, but you need to look out for these key elements. Now, when things go wrong, what does that mean? It essentially means, what are the options available when the parties begin to disagree? Can correspondence resolve the issue? Do they need to go to litigation, etc.? And so Dan will look at that aspect of it. I'll look at the corporate aspect in terms of corporate transactions and some of the best practices. Now, so what are some of the typical corporate transactions? There are many, of course, but I'll just highlight a few, which I'll discuss further on in the presentation. So joint venture agreements, mergers, continuations, sale and purchase transactions, finance transactions, plans of arrangement, and IPOs, initial public offerings. Now, let's look at joint venture arrangements. And this is a frequent use for BVI companies. Now, a joint venture arrangement is essentially when shareholders come together to form a company for a particular purpose. So whether it's to develop a solar project, whether it's to develop a health facility or to acquire an asset, a piece of property, etc. And so typically they put together the terms of the agreement in terms of shareholding. What percentage of shares should one shareholder hold versus another? What are the rights attached to those shares? How will the board be comprised? What are the restrictions on transfer of shares? And what are the provisions relating to payment of dividends? How will the profits be divided at the end of this transaction? Now, the issue with joint venture agreements and what I've seen over the years is that they typically arise after the company is formed. So initially they put together a standard company and say, okay, let's get into this business. And later on they develop the joint venture agreement. Now, what happens sometimes is that the joint venture agreement provisions will conflict with the provisions of the standard memorandum and articles that have been used. So for example, it might contain certain share restrictions on transfers, drag along, tag along rights, etc. But those would not have been reflected in your standard memorandum and articles. And from a BVI law perspective, the memorandum and articles governs. And so if there's a breach, for example, under the joint venture agreement, your remedy there is damages, monetary damages. But if there's a breach of the provisions of the memorandum and articles, then that can be enforced through the courts. So how do you deal with this conflict? The best way to deal with the conflict is to ensure that the provisions in the joint venture agreement which conflict with your sort of standard articles are reflected in the articles. So you'd make those adjustments. So for example, if it provides for approval of certain shareholders before a share transfer can be approved, or it provides for a certain way in which the board should be appointed, then those provisions should also be reflected in your memorandum and articles. So the best practice here is essentially consistency to ensure that the provisions of your joint venture agreement are reflected in your memorandum and articles. And I know some clients will be concerned about some of the provisions. So not all the provisions have to be reflected, but those typical provisions that are in your articles, for example, your dividend provisions, your share transfer provisions, the board composition, those are the provisions that you should mirror essentially in your memorandum and articles. Now let's look at mergers. So BVI is one of those jurisdictions that provides for a statutory merger. Not all jurisdictions provide for that. And the essential point about a statutory merger is that the assets and liabilities of the constituent companies to the merger flows with the surviving company. And so a merger is used for various types of transactions. So business combination or restructuring. What we have seen more recently is that clients are using merger provisions where you have a number of subsidiaries. And for example, if you're winding down, rather than liquidating each subsidiary, you can merge them into one and then proceed with your liquidation. So merger is a very useful process on the BVI law. So what are some of the documentation that you need? You need your resolutions, and the merger has to be approved by the board and also by the shareholders. You need to have a plan of merger, and this is essential because this will set out the terms of the merger, how shares are to be exchanged, etc. And then you also have your articles of merger. So there are various types of mergers. You have your standard merger where, for example, two companies will simply merge together. You have a triangular merger, which involves more companies, typically 3. You also have a reverse merger, which allows shareholders of one entity, one of the constituent companies to the merger, to become shareholders of the other entity. And that is typically used in a sort of listing scenario where the acquisition allows a company to be listed on a stock exchange. Now, one of the key areas of the merger provisions is that it allows shares of the constituent companies to be converted into shares of the surviving company and also into other assets. So that gives you tremendous flexibility in terms of how the merger can occur and what the resultant effect of the merger is. All right, there's also dissenters' rights. So persons who do not want to continue with the merger in the surviving company, they can dissent from the merger and they're entitled to payment of fair value of their shares. So the best practice here, I would say, for mergers is to have a good plan of merger, which ensures that the constituent companies, the shareholders in the constituent companies, their shares are converted into exactly what the arrangement is, whether it's shares in the surviving company or shares in another company or some other type of asset. All right. So now let's look at continuations. And here I'm dealing with continuations into the BVI. And, there are various reasons why a client would want to continue into the BVI, but some of those reasons would be what I explained earlier, tax neutrality, flexibility in terms of corporate transactions. So what are some of the documentation that you need for a continuation? First, you need to see the corporate documents of the entity where it's currently domiciled. There needs to be solvency verification. And of course, you need to have the memorandum articles that the company will adopt to come into BVI, along with the appropriate resolutions. So what I find here is that, one of the key issues is adoption of the appropriate memorandum and articles. So the company in its current domicile would have its bylaws, etc. And they might provide for certain things, the composition of the board, how dividends are paid out. And typically, sometimes clients continue into the BVI and simply adopt a standard memorandum and articles. And then they're all confused because the provisions differ significantly from what they had before. So what I would always suggest is that you look keenly at your existing corporate documents and then tailor the memorandum articles that will be adopted as best as possible. And that allows an easier transition for clients. So I would say the best practice is to ensure you have the appropriate memorandum and articles for the continuation, and also to understand the process in the other jurisdiction with respect to timing, when filing should be made, etc. Because we have seen cases where a company leaves a domicile, moves into BVI, and there's an issue as to when the transaction, when the continuation occurred. We clearly know when it occurred from a BVI perspective, but there's dispute as to whether the appropriate process was followed in the other jurisdiction. So an appreciation for the overall context of the continuation and how it operates, not only in BVI, but also in the jurisdiction that the company is moving from. I would suggest that as the best practice. So now let's look at sale and purchase transactions. And there are primarily two types: sale of assets And the key issue here is where a BVI company is disposing of more than 50% of its assets outside its usual or regular course of business. Under the BVI Business Companies Act, if that occurs, shareholder approval is required, subject to the provisions of the company's memorandum and articles of association. Many companies now provide they exempt that provision, and so it does not apply, section 175. And so they're able to dispose of more than 50% of their assets without requiring shareholder approval. Others take a different approach. So the board can say this is within our usual course of business, and they can dispose of the assets. So that's a key issue with respect to disposal of assets, and it's something you should look out for. So I would always suggest a proper review of the company's memorandum and articles to make that determination. Now, in terms of the sale of shares, this is another important area, and you need to look at the provision under the company's memorandum and articles, and don't always assume that it's standard or it just requires board approval, etc. Because sometimes when you do a search and you see the memorandum and articles, it's entirely different. There are restrictions on transfers, there are tag-along rights, drag-along rights, etc. So ensure that a review of the memorandum and articles is conducted with respect to sale and transfer of shares. Another key issue is the updating of the register of members, and registered agents of companies will be familiar with this issue. You do not become a shareholder until your name is entered in the register of members. So that's one key area which I'd always suggest that clients look out for to ensure that if they have purchased shares in a BVI company, their name is entered in the register of members and you're provided with a copy of that. Finance transactions. BVI companies are often engaged in transactions with banks and other lenders. And typically, the bank would require a legal opinion from an attorney in BVI. But the issue here I want to highlight primarily is as it relates to charge over assets. So the company's assets have been charged pursuant to this loan. And in order to ensure priority for the lender, that should be registered in the register of registered charges at the BVI Registry of Corporate Affairs. And that protects the priority of the bank. So if it was registered first, then the bank would have first priority in that instance. The other area is with respect to charge over shares. And this is a charge over shares in the BVI entity itself. And we'd always suggest that there be a notation on the share register with the registered agent. And that can also be filed at the option of the company at the Registry of Corporate Affairs, and would give notice to the world that these shares are charged. You should also consider amendments to the company's memorandum and articles, which would ensure that it's much easier to enforce the security. Now, the charge document itself, the share charge, would contain those provisions, in terms of how the share charge may be enforced. But these are some of the key elements that should be taken into consideration. Share register notation, and also possibly amendments to memorandum and articles. Now, plans of arrangement. These are not, typical transactions, but I think it's quite useful. They facilitate business combination, separation, disposal of assets, exchange of securities, etc., with court approval. So it can be a typical corporate transaction, but the provisions under the BVI Business Companies Act allows for court approval under section 177. And so this combines corporate and essentially litigation. And we have found this useful, in a few cases where, for example, in one case, it allowed the client to obtain exemption from US securities registration because the regime in the US at the time required some level of court approval for that transaction in order to allow the exemption to occur. And we were able to secure that under section 177 of the BVI Business Companies Act. In one other instance, this was a matter involving a BVI company doing business in Japan. and there was a proposal for capitalization of debt. And the court in Japan said, yes, this can be done, but the BVI company had to secure approval by the courts in BVI. And so although the transaction could have occurred simply from a corporate perspective, the capitalization of debt, by virtue of Section 177, we were able to approach the court and also to get the court's blessing. And so it can achieve significant results for clients. As I said, it's not a very popular use, but I think more clients should look at considering, a plan of arrangement in certain scenarios. And so the best practice here is really to have a good plan, a plan that explains exactly what the goals are, what the company wants to accomplish, and then, put it into effect. Now let's look at initial public offerings, IPOs. BVI companies have been used across the globe and are listed on various stock exchanges: NASDAQ, New York Stock Exchange, London Stock Exchange, Toronto Stock Exchange, Hong Kong Stock Exchange, and many more. Now the key area here, I think, for IPOs, is the due diligence process. Due diligence has to be conducted on the BVI company itself and also on its subsidiaries. And one of the key issues I find with IPOs is BVI law versus listing rules. Because if you're listed on NASDAQ or New York Stock Exchange, they have rules on corporate matters which might conflict with BVI law or differ. And so the prospectus will need to explain the BVI law position versus the US position. A key area in the listing process is a demonstration of shareholder protection and shareholder rights. And so that has to be explained from the BVI perspective as to what the rights of shareholders are, what remedies they have, etc. And so the best practice here, I think, is really to work closely with listing counsel to understand the listing rules of the particular exchange. And so you can advise appropriately as to the BVI law elements related to the IPO. All right, so that's it for me. I think, those are some of the notable types of corporate transactions and just some of the key points that clients using BVI companies should take into consideration. Now I'll hand over to Dan, who will look at, when things go wrong, how can shareholders, how can, parties engage in business with BVI companies, take action. So Dan, over to you.
Thank you very much, Chris. I think good morning, ladies and gentlemen. I think the first thing to start off with is to ensure we just appreciate how lucky we are in the BVI in terms of having the infrastructure we have for commercial dispute resolution, whether it's in the context of litigation, in our commercial court, which has been operating very well since 2009, seamlessly through the COVID crisis via Zoom, whether it's using the Insolvency Act and the insolvency remedies, which often have court aspect to them, or whether it's using our arbitration framework that we have in the BVI. We've had relatively recently revamped Arbitration Act. We have a well-resourced arbitration centre who will provide assistance in terms of contractual arbitration clauses. We have, as our final court of appeal in the British Virgin Islands, the Privy Council in London, which provides, I think, a consistency and is well capable of dealing with complex disputes and gives good guidance which can be adopted by the lower courts. And where necessary, we have access to the London, or pretty easy access to the London bar with its expertise and its specialization. So that should give clients and practitioners a great deal of confidence in terms of the ability to resolve disputes as they might arise in the context or following commercial transactions. And that's something to be aware of, I would suggest, as you think about your transactions, although nobody goes into a transaction expecting there to be a dispute. Now, if a dispute happens, What sort of remedies are you likely to get in the BVI? As Chris said, we essentially follow the English common law. We have some statutory differences, but substantially we use English law. And for a breach of contract, or indeed for a tort, the start point will be a claim for damages. And those damages, you can expect them to be calculated to put the successful party in the position he would have been, or she would have been in, had the breach of contract or the tort not happened. Although conceptually in the BVI, as in England, we have the ability to seek exemplary damages or punitive damages, those sorts of damages awards are only rarely made, in my experience. We also operate an adverse cost system under which the losing party to an application or to a piece of litigation, if it's in the commercial court, can expect their reasonable costs incurred in that proceeding to be paid by the opponent. There is also the ability to seek security for those costs as you go along. One point to be aware of is it has become increasingly difficult to obtain the costs of foreign counsel who are instructing BVI lawyers. And so that is something to make clients aware of as you move forward. The final remedy, which one can obtain as part of BVI litigation, is a final order. So that might be an order at the end of a trial under which, say, a specific real asset will be transferred from party A to party B, or indeed where some company records will be rectified or somebody appointed to the board of a company. Now, I make the point about the final order in contrast to what I'm going to talk about now, which are interim orders or interim injunctions. These are a very frequent feature of commercial litigation in the BVI, and most commonly in the context of corporate matters, they involve freezing orders or receiverships. Now, what each of these orders is designed to do is to hold the ring on an interim basis before there's been a final adjudication, which would happen at a trial, of the rights or wrongs of a particular dispute. They are intended to stop assets being dissipated or to stop steps being taken, which would make the point of the litigation, we use the term nugatory, but effectively make the litigation redundant. There would be no point having it because the asset concerned had been spirited away to another company, you know, in wherever it might be. They are capable of being obtained on a without notice basis, and they frequently are obtained in this jurisdiction on a without notice basis, namely without notice to the defendant in a proceeding. And again, this is the court here, in common with the court in England, taking a practical approach to the grant of an interim remedy, namely on the basis that because there is a risk of dissipation, you're showing the court on a prima facie basis that the respondent to the order or the defendant in the matter may not obey court orders, and therefore you need to get in without him knowing, get the order, serve it on the innocent third party, very frequently a BVI registered agent or a bank who will obey the order, to make it impossible or very difficult to transfer an asset or mortgage an asset. Included within both freezing orders and receivership orders are disclosure provisions, which will very often require respondents to the orders to give a list or to just give disclosure of the value and whereabouts of assets which they own up to a certain value. These orders very often will have, well, almost invariably, will contain a penal notice, which makes it a contempt of court to not obey them for any person who has notice of the order, which can include third parties who are not actually a party to the litigation. They have become used, I mean, they are being actively used at present in cryptocurrency disputes and thefts of cryptocurrency. There's been a recent reported case of a freezing order obtained in the BVI against persons unknown in respect of a cryptocurrency theft. Our firm got one a year in September, again, in the BVI against persons unknown in respect of a freezing order, to stop a theft or to deal with a theft relating to cryptocurrency. Receiverships are allied, I would say, to a freezing order, and they very often go in tandem. A receiver is an officer of the court in the BVI, normally a licensed insolvency practitioner, who will be appointed to take steps to give effect to the court's orders. Now, you can have receivers with very wide powers indeed, who essentially assume interim control of a company, or you can have receivers to take very specific steps. They are a serious order because clearly the receiver can operate in a way so as to cause serious harm to a company, either if he exercises his powers in too draconian a nature, or if he, and this is not his fault, but if it becomes known, for example, that you have an operating company, for example, in financial services, which has a receiver over it, that gives an indication that there is something seriously wrong with that company, or there may be something seriously wrong with that company, and that can cause a real problem with investor confidence. Being a receiver is a difficult job because they have a tightrope to walk between discharging their duties under their order of appointment and operating in a way which doesn't cause damage or unreasonable damage to the company which they're supervising. Now, because of these risks from these interim orders, a condition of getting them in the BVI, as in England, is that the party who obtains the orders has to give an undertaking to the court that A, he has the financial resources to pay damages if it turns out that the order should not have been granted and it has caused actual damage to the respondent, and B, that he is willing to do so. And this is a serious promise which the applicant makes, and if it is ignored, the applicant can be pursued in contempt ultimately. So that's something to think about. In my opinion, these orders are incredibly valuable, particularly in the context of asset recovery. Also, they can be very useful for liquidators seeking to gather in assets into an insolvent estate. We'll come on to insolvency, we'll touch on that later. But it is important that clients not give in to the temptation to go for a sort of slash and burn approach with these interim orders, but that they calculate what is the minimum effective relief which they can get, and then seek that much and no more. Alternatively, to perhaps look for opportunities, having got their freezing order or their receivership or both, and actually got control of assets, to be reasonable in the interpretation of the operation of this order. It's open to respondents to apply to court to vary the order or to set it aside. But the reason I'm suggesting this caution is that you can have freezing orders which have been obtained, or receiverships which have been obtained on basis A, which when you actually get into the disclosure, it turns out was not accurate. We have a case along those lines at present. And there is a real risk to an applicant who has been too bullish in the operation of the interim order that they can actually cause a lot of damage, for which they will be expected to compensate the respondent. So I am advising you, if you're talking to your clients, to highlight that to them. They're excellent, excellent remedies which we have, and they are there to be used, and they are used very frequently, but they should be used with elements of common sense and with thought. It's particularly from some jurisdictions, you can get instructing counsel who A, are not used to these orders because they're relatively unusual. I mean, in civil jurisdiction countries, they don't have much in the way of interim orders, as I understand it, and I don't think in the United States they have anything like the panoply of interim or prejudgment interim orders, which we have. And so there is a temptation to clients and to their advisors abroad to be over enthusiastic in the deployment of these orders. The other order, which we very frequently see in the BVI, is the Norwich Pharmacal order. And this is an order which is granted. The basis of it being granted is that the applicant needs to demonstrate that he or she has been the victim of a wrong. That wrong is widely construed. It can include a breach of contract. It can include failure to give proper disclosure in the context of divorce proceedings. It can include piracy in respect of intellectual property rights. It can include serious attempts to avoid paying a judgment which has been ordered abroad. By obtaining that order, a third party, the basis of obtaining the order is that a third party in the BVI, normally a registered agent, has innocently facilitated the wrongdoing of another by, again, in the BVI, normally providing registered agent services. And because of that, that third party comes under a duty to assist by providing what's called full information. And again, in the context of the BVI, that normally includes information such as documentation and information relating to the identity of an underlying beneficial owner. It might relate to forms of indemnity there might be between the registered agent and their ultimate instructor, again, with a view to trying to establish a pattern of ownership or an attribution of ownership of an asset. It may include information and documents as to whom have certificates of incumbency been sent, or certificates of good standing, with a view to identifying assets or bank accounts abroad. These orders, Norwich Pharmacal orders, again, are capable of being obtained without notice. They are capable of being obtained with a gagging seal and gagging provisions, which prevents a client or a registered agent speaking to its instructor to tell them about the order. And this presents a practical difficulty for the registered agent, because when it's bound by the seal and gag, it's unable to tell its client that it has the order, and it's unable to ask for funding to perhaps challenge the order or seek to vary it. And that is an issue with which registered agents in the BVI are regularly faced. Norwich Pharmacal orders themselves will normally contain a penal notice upon them, which makes it a contempt of court to breach the terms of the order, and in particular, either to fail to give proper disclosure or to tip off your client. And again, the applicant for a Norwich Pharmacal order will usually give a cross undertaking in damages, but which is rarely engaged in the context of Norwich Pharmacal orders, but he will also give an undertaking to pay the reasonable compliance costs incurred by the registered agent in complying with the order. Now, in my experience, those compliance costs have been in the region of I would say $3,000 to $5,000. I'm aware of compliance costs which have been significantly more than that, awards which have been made more than that. The compliance costs have to be justified, so a registered agent would need to set out a basis on how he had arrived at a figure for compliance costs, whether it might be by reference to the staff that were doing the work in sorting out the compliance, or indeed the costs paid in obtaining legal advice on the order. So they are a very, very important remedy in the BVI. Now, the next thing I'd like to go on to is section 184I, unfair prejudice actions. And Jane, can I ask you to put the slide up, please? Thanks very much. Now, Section 184I in the BVI Business Companies Act is a provision which is designed to provide relief to a shareholder who feels that they are being treated unfairly in the context of their company, in the operation of their company. They are a remedy which is frequently deployed in the BVI and which particularly crops up when you have private companies which perhaps have got two shareholders on a 50-50 basis, or two or three shareholders, and two of the shareholders gang up to harm the interests of the other. For example, perhaps to sell the assets of at an undervalue to a connected party in such a way as to deprive the complaining shareholder of the proceeds of the transaction. Now, from this list here, you can see that the courts in the BVI have got the very wide range of remedies available to them. But this list is given by way of example. It's not exclusive. And the BVI courts have been very clear that they will cater the remedies they grant to the particular facts which with which they're presented. And they will also seek to do so in a way which deals with the conduct of the company prospectively, rather than focusing on what has happened in the past. Although as part of Section 184I relief, damages and compensation can be given for past actions. Now, what is interesting about them is one of the remedies is to put the company into liquidation, and that effectively has the effect of killing the company. And that is a fairly nuclear option. The courts and the BVI have said that they are relatively reluctant to do that, and they seek to make the relief they grant proportionate to the wrong which has happened. What I've found in the cases I've done involving Section 184I is that actually the fact that a liquidator can be appointed can actually push the parties to reach a settlement. And the reason for that is a sudden liquidation, which is not actually wanted by the wrongdoing party, can often crystallize effectively realizing assets at a suboptimal value. That's a very jargony phrase there. So what I mean by that is that no party may want a liquidation, and that will actually push the parties to come into some sort of settlement. A claim under Section 184I will include the company. It is also quite fact intensive because these claims are very fact sensitive. And so you will need to, the lawyers will need to conduct an investigation. They will need to take good witness statements. They'll need to have a thorough review of the documentation to try and work out what has happened, to be specific as possible in the way in which they present the case to the court. It's a very, it's a very good remedy because it has such flexibility, which in a jurisdiction which has hundreds of thousands of active companies is extremely valuable. Right, thank you, Jane. The next thing which I would like to touch on, and I'm afraid this is a whistle stop for, is issues of insolvency. Now, I think we're probably already familiar with the concept of a voluntary liquidation. This is a process whereby a solvent BVI company is effectively put to sleep, and without the appointment of an insolvency practitioner, it follows a director making a declaration of solvency and will include a statement of the company's affairs. If the director makes a statement, but without proper grounds to do so, he can render himself liable to a fine of up to $10,000. And a liquidation plan will have to be prepared, which includes the reason for the liquidation and the name and address of the voluntary liquidator. Once appointed, the voluntary liquidator assumes control of the company's assets, although the directors remain in office. Very importantly, in the BVI, companies which are put into voluntary liquidation can be restored upon application to court. There are very good reasons for putting companies into voluntary liquidation commercially, but it's also a step which is quite often taken sort of in order to conceal, basically to muddy the trail as a fraudster seeks to escape with his proceeds. So it's something to take seriously. You also have insolvent liquidation, which is when a company hits insolvency, i.e. it's unable to meet its liabilities as they fall due, and it can put itself into insolvent liquidation. And indeed, if a company is approaching insolvency, its directors will be under a duty to think about aspects of insolvency and to take into account the interests of potential creditors. The parties who can apply to court to put a company into liquidation are the company itself, a creditor, a member, a supervisor of a creditor's arrangement, the FSC, or the Attorney General. Once a company is put into liquidation, a BVI licensed insolvency practitioner will be appointed, and his job will be to analyze and review claims of creditors and also to seek to gather in the assets of the company. Something to be aware of is there are really excellent international provisions now to assist a liquidator of a BVI company be recognized abroad or seek the assistance of foreign courts. And that can be really very important in terms of getting information or commencing litigation to gather in assets abroad. There's a very well-established framework. The framework the other way is not so well done in the BVI, but the BVI court will give assistance to foreign insolvency office holders. And that international aspect of liquidations is very important in the BVI. Right, we are rapidly running out of time, I'm afraid. So I'm going to touch just very, very briefly. In the BVI, under the relevant legislation, which is the BVI Companies Act, but also the BVI Insolvency Act, there are provisions for reorganization, which some with court assistance, as Chris touched on, and some without. The idea of these is that a company can, in certain circumstances, obtain a moratorium on being wound up by its creditors if it can demonstrate that it has a significant majority of creditors by value being willing to countenance such a plan. And this can often be of interest because it is not at all uncommon in the context of a liquidation that creditors only get small, a few cents in the dollar. And it might be the case that if the company is able to continue and trade out of its problems, those creditors will be paid off or paid more in the future. I'm afraid we don't have the time to go into that in any great detail, but I think it is something which practitioners and service providers need to be aware when they are advising a company, which firstly has got a manageable number of creditors, a relatively small number of creditors that can be corralled together. And secondly, where there is a risk of litigation, perhaps by one creditor or the company being put into liquidation by one creditor, which will upset the entire apple cart. Now, I think I have exhausted the time available to me, and I'm sorry this has been something of a whistle-stop tour, but I hope it has raised a bit of consciousness, as it were, and if there are any questions, we will try and answer them. Thank you very much.
Thank you, Dan. So we do have a question in the queue, and we also have one of our attendees raise their hand. We'll get to that next. The question is, and I believe this is for you, Dan, how about the handling of repurchase agreement disputes where the buyer does not honor the returning of the asset to the seller on the specified date?
In such a situation, I think there'd be two things to look at. Number one would be depending on the nature of the asset, possibly to get some sort of interim order to freeze the asset, to stop it being transferred or mortgaged or otherwise moved out of reach. I think such a dispute would ground a claim in damages to include costs of bringing the application. And you might well seek a final order of specific performance where you would seek an order of the court ordering the counterparty to the contract to actually fulfill the terms of the contract. So it's easy to rattle that off. Litigation always has its difficulties, but it seems to me that is quite like that would be a sensible approach to such a problem.
Okay, do we have any other questions for Dan or Chris? All right, well, thank you again for attending, and we are certainly available for any follow-up questions by email or give Dan or Chris a call.